Hello, everyone, and welcome to Nexii's first webinar of 2013 on the topic of Public Listings 101. My name is Lucy Hoffman, and I am the Head of Operations at Nexii. Presenting today's session is Tim Wood and Katy Norman of international law firm White & Case. Tim and Katy will be providing you with an in-depth look at what it takes to list on Nexii's public social stock exchange board, operated in collaboration with the Stock Exchange of Mauritius. The IX is the first publicly regulated board on which eligible social businesses or impact funds can raise capital. Before we begin, I'd like to introduce Nexii and today's presenters. Nexii is an impact investment advisory firm. We are dedicated to increasing the flow of capital to businesses and funds whose primary intent is social or environmental impact. Nexii's core business is providing platforms for raising capital, either publicly on the IX or privately on IC or Impact Capital platform. However, we also designed the Nexii Webinar Series to respond to the need for additional exposure to tools and resources that would assist practitioners in impact investing to more effectively manage reporting, due diligence, and capital raising needs. Since these webinars began, and to respond specifically to the need for education and advocacy in the sector, Nexii has established a public benefit organization, the Impact Trust. The Impact Trust operates independently and is able to respond to overall sectoral needs to support impact investing broadly. In the future, these webinars will be hosted by the Impact Trust. To sign up for notices on future webinars, go to www.impacttrust.org.za and add your email address to subscribe at the right-hand side of the homepage. Today's working session will be an hour in length and include a Q&A session at the end. All attendees will be on mute throughout the session. If you'd like to submit a question during the presentation, you can do so by typing them into the toolbar on the right-hand side of your screen under Questions. At the end of the webinar, I will take questions and facilitate the responses with Tim and Katy. This webinar is being recorded and will be made available after the live version on the Nexii website, www.nexii.com. Tim Wood is an associate in White & Case's Capital Markets Group in London. To date, Tim has undertaken a variety of international finance work in the capital markets, bank finance, structured finance, derivatives, securitization, and restructuring spaces. Katy Norman is a trainee solicitor in White & Case's Capital Markets Department in London. Tim and Katy, thank you for joining us today, and over to you.
Good afternoon, everybody, and welcome along to our presentation on what it takes to list a social business. We're going to start by just reminding ourselves quickly with a brief description of what the IX is. Then we're going to move to discussing the benefits of listing on the IX, go through why listing on the IX is beneficial for the issuers. Next, we'll just go over various legal aspects of a listing and what companies who are looking to list should think about. We will then discuss the various methods of listing. There are a number of different ways that we can do this. Not mentioned here in this introductory slide, but we will give a brief discussion about the relative advantages and disadvantages of issuing and listing debt versus equity. Next, we'll move on and discuss the listing process itself and the listing document. Then we will discuss how not only is the procedure to list at the outset, whilst your securities remain listed, there are a number of ongoing obligations and accountability to respect. And then finally, we'll wrap up with a conclusion.
Okay, so looking first at what the IX is. The IX is the world's first impact exchange board operated by the Stock Exchange of Mauritius. It's the first initiative of its kind linking qualifying social and environmental purpose entities and impact funds which together are collectively known as impact issuers, and this is how we will refer to them, with a global network of impact investors in an organized, efficient, and regulated manner on a modern stock exchange platform. The Stock Exchange of Mauritius is one of Africa's leading exchanges in terms of market infrastructure and operational excellence. The IX provides the critical infrastructure for verified impact investments, trading, and liquidity, and importantly, it challenges exclusively aid-based approaches to addressing and solving, hopefully, social and environmental problems.
So what are the benefits of listing on the IX? First up, access to capital for growth and scaling impact, both at the time of listing and through further capital raisings. Rather than relying on funding from a limited number of sources, for example, a bank loan or specific limited number of investors, listed shares or bonds can be issued to and then bought and sold, traded by a wide range of investors in the IX marketplace. Next, we have the mission protection. This is a key benefit that has been built into the IX listing rules. The listing entity must be accredited as such by an accredited nominated impact advisor, or an NIA. The NIA is responsible for verifying that the applicant meets these impact criteria and ensuring that the applicant has received at least one qualifying external accreditation award or rating certificate relevant to the industry or sector of the applicant. Another benefit is the demonstrating commitment to impact objectives. Commitment is demonstrated by fulfilling ongoing requirements set out under the listing rules, such as filing half-yearly and yearly impact reports and annually reconfirming its qualifying external accreditation award or rating certificate. Improving public profile, in turn helping to maintain liquidity in the company's securities and access additional sources of financing. This is critical to scale up impact on the ground and enhances the company's status with customers and suppliers and investors. Furthermore, enhancing management accountability and efficiency is brought about by the rigorous disclosure requirements under the listing rules. As well as issuing impact reports and financial reports, applicants must also have an appointed impact performance director responsible for monitoring and reporting on impact performance, and must notify the Stock Exchange of Mauritius and issue a press release when a material change in its affairs occurs. Finally, there are many strategic benefits. Listing is a move of significant strategic implications, structurally and culturally, and is ultimately a seal of approval and for a company's image. By listing and adhering to the listing rules, the applicant is consistently reinforcing its credibility and demonstrating its commitment to social change and improvement, all the while its securities remain listed.
Okay, turning to general legal considerations, we'll now touch upon the initial considerations that should be in mind when contemplating a listing, corporate considerations, so these are company-related issues that require attention from an early stage of the listing process. We'll also discuss the regulatory requirements of listing on the IX, and finally we'll touch upon why and what types of advisors should be appointed.
So looking at initial considerations, an applicant issuer would need to do a little bit of soul searching at the outset, because it's quite an undertaking to perform a listing. The company and its directors will take on a lot of responsibility, and they will be bound by the listing rules, not just for the initial listing, but also in an ongoing fashion. When preparing for the listing, the issuer, its management will need to set out a timetable, and will, perhaps depending on the size of the applicant, create certain working groups who will need to focus on specific areas of the listing. There are a number of sort of questions that the management of the applicant will need to ask itself. Is the incumbent management team the correct one to take the business forward? Are directors ready for increased responsibilities and restrictions? Are all the key employees tied in? Is there any further recruitment needed? Has the company appointed an impact performance director who is responsible for monitoring and reporting on impact performance? They would need to assess the market. If they're seeking to list by way of an initial public offering, they would have to ask themselves, is the company saleable given its recent trading record? Are there any acquisition or strategic initiatives to be completed prior to a listing? Is now the time for a listing given the state and maturity of the business and the market conditions? If not, what other financing options may be available? Equally, if an applicant was looking to list bonds, will the company be able to repay investors, i.e. be in a position to make regular payments of interest and principal? Are there any existing financing agreements which prevent the company raising new bond financing? And it would have to ask some questions about its impact motives as well. Does the company have appropriate certification by a social environmental standards or rating body? Have sufficient impact-related performance measurement and monitoring systems been implemented?
Okay, turning to corporate considerations. These are largely the same for an equity or a bond listing, and most of these issues can be unearthed by performing due diligence on corporate documents and contracts and discussing historic and future performance plans with the heads of each relevant business unit within a company. So firstly, the company status and constitution. The applicant must be duly incorporated, and its constitutional documents, such as its articles of association, must be examined to ensure that it is suitable for life as a quoted company. For example, for an equity listing, there should be no restrictions on share transfers, and if there are, they will need to be removed by special resolution, and so any changes should be identified as early as possible. In terms of management and employees, directors and senior employee service contracts must be put in a form suitable for a publicly listed company, and if applicable, it should be determined if management has any conflict of interest with regard to any other group companies. The company must also comply with any applicable corporate governance codes and rules which are designed to protect investors. A company with an appropriate board of directors, management, and other systems in place is likely to be more attractive to investors. The company will also need to ensure policies are in place to adhere to applicable anti-corruption and anti-bribery legislation. In terms of banking facilities, the applicant should be reviewed to ensure that they are sufficient for capital requirements of the publicly quoted company, taking into account cash flow from operations and the proceeds of any new issue of shares. Key contracts should also be reviewed to ensure there is no change of control or other provisions that would be triggered by a listing and which would have an adverse effect on the business of the company. IP and real estate should also be reviewed to verify ownership, and the scope of IP rights should be determined, and there should be no unresolved environmental or planning issues in respect of real estate assets. Most relevant to an equity listing, employee share and pension schemes may be considered preferable to incentivize employees at a time when their commitment is vital. Insurance should also be reviewed to ensure it's adequate for protection following a listing. In terms of litigation, the applicant must ensure it's in control of any actual or potential cases of litigation it is pursuing or defending, and any material litigation will need to be disclosed in a listing document that we will discuss later on. And finally, in terms of IT, any applicant should ensure it has reliable and secure IT infrastructure, particularly if it needs to rely on this heavily to conduct its business.
An applicant looking to list must also be very aware of the regulatory requirements for the listing. An offering of securities, shares or bonds is usually highly regulated under securities laws and regimes in almost every jurisdiction to protect investors. This is by ensuring that the issue and the trading of securities is conducted in a fair and orderly manner. An issuer looking to issue and list on the IX would have to take note of the IX rules and comply with those rules, not only for the initial listing, but for the ongoing disclosure and ongoing requirements. It would have to look at the laws of its own jurisdiction in terms of issuing securities in its own jurisdiction. It would have to take stock of the laws in the country of where the stock exchange is, which in this case is the Stock Exchange of Mauritius. And then it would also have to be aware of any regulations that would be applicable in the jurisdiction of its target investors. In each case, it's advisable that some local law is local legal advice is taken. There also can be certain international guidelines and standards which may not carry legal effect, but are standard market practice and would also need to be respected.
Okay, turning to the appointment of advisors. Firstly, it's important to realize that advisors play a vital role and will help prepare the applicant for listing and aid the company to comply with subsequent continuing obligations. Advisors are usually appointed early on and it's customary for a company to enter into an engagement letter with its various advisors, which will clarify the key terms of the engagement, for example, the scope of the advisor's role and its responsibilities and payment. Each social business who seeks to list on the IX needs to appoint both an NIA and an IVA, both of which are collectively known as Authorized Impact Representatives, or AIRs. Nominated impact advisors, NIAs, assess the suitability of an applicant to the IX board and assist the application for listing. Specifically, the NIA will advise the applicant and its directors on the IX rules. It will provide the applicant with appropriate information about financial, legal, and regulatory requirements. It will assist the applicant in obtaining relevant certificates, impact assessment, and impact performance documentation, and it will also, amongst other things, act as a liaison between the applicant and the Stock Exchange of Mauritius. The Impact Verification Agent, or IVA, will assist the applicant satisfy its transparency and ongoing reporting obligations. And in particular, the IVA is required to perform a rigorous analysis and review of the impact information of the social or environmental business and verify the impact reports at the end of each financial year. The IVA could be a company, partnership, specialist consultant, or other advisor with sufficient skills and experience. Legal advisors will also be needed to assist in preparing listing documents and fulfilling various legal and due diligence procedures. Auditors will also be involved to review the company record for the benefit of potential investors, and they will also prepare financial statements typically required as part of the listing process. Corporate advisors will specifically be involved in an equity listing, and they will oversee the whole listing, including assessing the financial suitability of the company for listing. Financial advisors will be used in a debt listing, and this is typically an investment bank which acts as a lead manager and takes a leading role in the listing, advising the applicant on market conditions, risk, pricing, timing, and structure, and if it's advisable to list in one currency rather than another. It's envisaged that in most cases, the corporate and financial advisory role in a listing on the IX would be performed by the NIA. Clearing systems will also be involved in a bond issuance, and these are financial institutions that are facilitators of interest and principal payments under the terms of the bonds and are responsible for electronically recording transactions or settling trades. PR consultants will also have a valuable role to play in the success of a listing by generating press interest and positive publicity to help ensure potential investors are made aware of the company and its products and services. This, in turn, should help generate maximum interest in the company's securities. Finally, specialist advisors, such as tax advisors or actuaries, may also be needed depending on the nature of the applicant company.
When looking at a listing, there are various methods of listing, and they mainly depend on whether there are securities that are in existence already, i.e. shares that have already been issued or bonds that have already been issued, or whether the listing is going to take place at the same time as an issuance of bonds or shares. We can go through a few of these now. If we look at an introduction, that is a listing that's not involving an issue of new securities or marketing of existing securities. Those securities are already issued and held by investors and issuers, and the issuer, is already a publicly limited company, in which case the securities must be of such an amount, a large amount, and widely held that their marketability can be assumed. We have an offer for sale, which is an invitation to the public by or on behalf of the holders to purchase securities of the issuer which are already in issue or agreed to be subscribed for. An offer for subscription is an invitation to the public by or on behalf of an applicant company to subscribe for the securities of the issuer not yet in issue or allocated. A placing is subscriptions for or sale of securities by the issuer or an intermediary privately from persons selected or approved by the issuer or intermediary. We have a rights issue, which is an offer to existing securities holders to subscribe for further securities in proportion to their holdings. A consideration issue is issuing securities in consideration for the acquisition of assets or an acquisition merger with another company. A capitalization issue is an allotment of further securities to existing shareholders in proportion to their existing holdings, credited as fully paid from the issuer's reserves or profits. We also have conversion of securities from one class to another, from shares into bonds or vice versa. We have an exercise of options or warrants to subscribe for securities. And there can be many other different types of methods of listing and issuance of securities, applicant issuers can speak to the SEM and seek approval for its particular issuance requirements. When we look at, as we envisage for many companies that are looking to list on the IX, that they would already have existing securities, it would be really an introduction is typically the most used for its efficiency.
Any applicant who wishes to list on the IX has a choice of either a debt or an equity listing, and these are different, so we just wanted to highlight the differences between them. Focusing first on debt, this is a form of incurring indebtedness or borrowing, and it must be repaid with a regular payment of interest and principal over a fixed term. In a debt listing, the shareholding of existing members of the company will not be diluted. Existing shareholders will earn a greater return on their stake if the company grows and becomes more profitable from raising debt finance. The bank or lending institution will not have ownership of the business, and this is important to understand. The shareholders will retain control of a company that lists. The business relationship with a bank ends on repayment of finance. A debt issuance can either be short-term or long-term in nature, and the amounts of debt raised will be known, and therefore this brings the advantage that it will be easy to budget for. But it should be remembered that too much debt can lead to cash flow problems. Plus, a company would be seen as high risk, which would obviously deter investors. And too much debt could also limit the ability of a company to raise capital by issuing shares. Turning to equity, this is a form of issuing shares to raise finance. And unlike with a debt listing, there is no obligation on the company to repay the investment. So a company won't have to channel profits to repay any loan. The shareholding of existing members will be diluted, and with that comes a loss of control. The new shareholders will obtain a stake in the company, and so an applicant will have to consult with investors before making big or even routine decisions. And these are decisions which the applicant company may disagree with the investors on. There will also be a duty to pay a dividend, and this will be discretionary depending on how well the business is performing. And in addition to debt or equity, there is also the option of convertible securities. And as Tim's already alluded to, these are securities that can be converted into a different form. For example, convertible shares or convertible bonds. And it's advisable that an applicant company takes financial advice as to the type of securities most suitable for its business.
So moving on a little bit to the IX rules themselves and the listing requirements. The listing requirements are set out at the beginning of the listing rules, and perhaps the key ones for the IX, and the fact that the IX is designed specifically for social enterprises and to demonstrate impact assessment, are the impact assessment requirements. These fall under 5 major categories. The first is the social and environmental purpose and intent. Second is a clear purpose and theory of change that forms the basis for performance assessment of indicators to demonstrate output, outcomes, and social performance. Thirdly, we have performance measurement and monitoring systems. These must be in place, and the applicant must demonstrate a commitment to ongoing monitoring and evaluation. It must have a sustainable business model reflecting social and environmentally responsible business practices and a market-based approach to achieve its purpose. What we mean by this is so as to guarantee a return on capital to meet the return obligations of investors. Lastly, I think, as we've mentioned before, the company must have an impact performance director appointed who is responsible for monitoring and reporting on impact performance. There are various other listing requirements set out under the listing rules. A couple of examples would be that on listing, the company must demonstrate financial statements for at least one immediately preceding year, which would be prepared in accordance with international regulations. Another example would be where debt is already issued, it must be held with a minimum of 25 debt holders. However, for many applicants, it's envisaged that they may not necessarily be such an established company that can give a financial such financial records or demonstrate that they've already issued debt. So the Stock Exchange of Mauritius offers certain exceptions and waivers which companies can apply for directly. In particular, under Listing Rule 2.2, an applicant with no previous proven track record, provided the applicant submits a sound business plan certified by an NIA covering at least 3 years ahead, hence, and demonstrating clearly sustained viability and impact targets, can also seek a listing. When making an application for listing, there is various listing documentation that needs to be submitted. This is a suite of documents that the various advisors will help prepare, including a listing document, which we will talk about in a second, a copy of an impact assessment, latest impact reports, certificate of incorporation of the company, board resolutions authorizing the application, etc. Excuse me. If the aforementioned eligibility requirements are satisfied, the applicant must file initial application documents at least 10 business days prior to application meeting, and then final application documents at least 3 business days prior to application meeting. There are fees involved for submitting an application to listing. For a new applicant, it's $3,700. For an applicant that is already listed but is seeking to list further securities, it's $1,850.
As Tim mentioned, any applicant who seeks a listing on the AIX must file a listing document, and this will disclose information about the company's background and principal activities, its parent and group business, if applicable, its financial position, future prospects, and impact position, and this is often in the form of an impact report, its management structure, and the listing document will also include details of any material agreements and the securities it is seeking to list, including the terms and conditions of their issuance and distribution, and also there'll be details about its advisors, and as I previously mentioned, any material litigation will also need to be disclosed in the listing document. This document must comply with the IX listing rules, which form the basis of the template listing documents that are available, which I will discuss in a moment, and the requirements of each jurisdiction in which the securities are being offered. So template equity and debt listing documents are both available, and these must, if used, then be completed according to the listing rules. And specifically, Annex 2 highlights some guidance which should be a primary source of reference when preparing the listing document. It should also be completed according to the nature of the applicant's business. We suggest that the best way to do this would be to look at examples of listing documents from other companies that have previously listed on the Stock Exchange of Mauritius. And these are publicly available and can usually be found by going to the Stock Exchange of Mauritius website to see which companies are listed, and then from there searching those companies' websites individually for the listing documents. And these should be quite easy to find.
So on this slide is a brief summary of the stages of a listing process. At the outset, the company would be making the decision to proceed with the listing and would be looking to appoint and consult with advisors as to exactly what kind of listing it's seeking to do. Would be having preliminary discussions with the Stock Exchange of Mauritius's listing division, letting them know that they would be seeking a listing. Would begin the preparation of the listing document. As Katy just described, this is quite an involved document with a lot of disclosure, and will take a company some time to be able to populate and complete this document. They will then lodge the listing document with the Financial Services Commission, which is the financial regulator in Mauritius, and also with the Stock Exchange of Mauritius, and make its application to list. The application would be reviewed and conditional approval would be granted, and then there would be some formal appointments of various agents which are required for the settlement and trading of securities, which includes the registry transfer agents and the central depository and settlement company. The listing process overall would be expected to take 6 to 8 weeks, but that would also, on top of that, in advance of the 6 to 8 weeks, would be more time for the company to prepare itself for the listing internally. You then have the admission to the IX board, so your listing is complete and successful, and from there investors will be able to trade your listed securities. All of these, as I just sort of briefly pointed out, that these stages here will depend on the preparedness of the company and the nature of the company, the type of the securities that it's issuing, the method of listing, the vibrancy of the market, how many investors there are that are seeking to invest in these types of securities, and also the size of the transaction, how many securities are being listed.
Okay, turning now to continuing obligations. IX-listed companies have a general obligation to immediately disclose information which a reasonable person would expect to have material effect on the price or value of its securities. A company listed on the IX must undertake regular reporting and disclosure of all material relating to the business to maintain its listing on the IX. Specifically, in terms of impact information, semi-annual and annual impact reports must be published, and a company must annually reconfirm its status as an impact entity and its compliance with relevant regulatory requirements, as per IX Rule 12 and 21. In addition, a company must demonstrate procedures are in place for directors to identify and manage certain risks and compliance with international standards and codes of conduct. In terms of material changes in an applicant's affairs, in the event of a material change in how an IX company does its business, a press release in at least one Mauritian newspaper must be prepared as soon as reasonably practicable, as per IX Rule 13. Corporate transactions must also be disclosed, again by a press release, and this must be issued as soon as reasonably possible. Such corporate transactions would include a significant transaction, which is one involving a major acquisition or disposal of part of the applicant's business, or a related party transaction in which the transaction between a listed company and a related party of that company, a related party being a substantial shareholder or a person who is or was in the 12 months prior to the transaction a director. Financial statements, according to IFRS standards, must also be published as per IX Rules 14 and 15. Quarterly financials must be filed with the SEM as soon as possible, but not later than 45 days after each relevant period. Annual financials must also be filed not later than 90 days after the balance sheet date of the company. The annual financials must also be included in the company's annual report, which must be sent to shareholders. In terms of closed period and insider dealings, directors and senior employees are restricted in their ability to acquire and dispose of the company's securities as per IX Rule 23. They must not deal in the company's securities in the 1 month preceding the publication of financials. Any interest or change in the interest of an insider or associate of an insider must be notified to the SEM before the end of the day following receipt by the IX company of the relevant notice indicating it of such. And finally, ongoing eligibility requirements must also be satisfied as laid out in IX Rules 33 to 36. And these provide for, amongst other things, that securities must remain freely transferable and must be able to be settled.
We think it's right that responsibilities and liabilities of the company and directors should be pointed out. From a corporate governance perspective, directors would assume the responsibility for compliance with the IX rules, and the directors must ensure any information it notifies to the SEM, to the Stock Exchange of Mauritius, or publishes in the press under the IX rules is not misleading, false, or deceptive. Directors would be collectively and individually liable. They should ultimately ensure that the company's strategy is consistent with its purpose. There are sanctions that are set out in the IX rules. These would be along the lines of a censure from the Stock Exchange of Mauritius. Even a listing could be suspended or cancelled. Of course, the company under the IX rules has a right to appeal. Similarly, when performing the listing itself with the listing document, the company and the directors are responsible for the information and the disclosures set out in that document, and they may potentially be liable for any losses resulting from any misstatements, material omissions, or inaccuracies.
Okay, to conclude, as may be inferred from all that we've talked about in this presentation, the issuance and listing of securities on the IX is a very involved process. There is a lot at stake financially and reputationally if the process is not successful. And we therefore think that the key is for a company to be well prepared, well informed, thorough, and accurate. Although there is a lot of hard work involved, once successfully listed on the IX, a company will have access to many more investors, which will hopefully provide it with the finance it requires to scale up its impact and realize its potential whilst protecting its mission.
Thank you very much. We look forward to receiving any questions.
Thank you, Tim and Katie. We'd like to move now to questions from the audience. We have received some great questions and a lot of questions just kind of on logistics. So I guess just to start from the top, we had a question, where can I find the authorized impact representatives, or what Nexii calls heirs? So I would direct you to the Nexii website. You'll see a register of heirs and whether or not they can serve as the nominated impact advisor, which really helps social businesses with the listing process, and then also those who are independent verification agents. So those would be the heirs that will help audit your impact reports on an annual basis. So there is a register of heirs on the Nexii website that you can see at www.nexii.com. We also had a question, and I'm actually going to give this one to you, Tim, about where they can find, where can I find the legal help necessary to go through the listing process. I know, Tim, this is something that we've talked about, a lot of social enterprises having difficulty with. So maybe, Tim, I'll turn that over to you.
Sure, thank you very much. We would really say it will depend on where the applicant company is based. It would then be advisable to research, perhaps speak to its legal advisors that it may have, as to whether they can recommend any law firms that have experience of issuing bonds or shares in the local jurisdiction where they are, and then seeking out the recommended counsel and speaking with them and explaining that they are obviously looking to list on the IX, that they are a social enterprise, and to try to negotiate a representation from their legal counsel, which would be perhaps on a reduced fee basis or on a pro bono basis.
Great, thank you, Tim. We had a question whether or not there'd be a copy of this presentation. I would just like to remind you that these webinars will be made available on our website in the future, and you can see the recorded version of this webinar. White & Case has also put together a guide for listing on the IX. So if any of you are interested in that guide, we would be happy to send it to you. Just please send an email to info@nexii.com, or else you can also email me, lucy@nexii.com, and I'd be happy to send you over the excellent guide that White & Case put together that really kind of mirrors this presentation. It's a great guide to look at as you contemplate whether or not listing on the IX is right for you. With that, actually, we do not have any further questions. Let me just see. Well, thank you all. If we didn't get to your question today, you may send them again to info@nexii.com, or please send them to me at lucy@nexii.com. I'd like to thank Tim and Katie again for presenting today's session, and thank you all for your participation. We look forward to having you on our future webinars.